The second the Supreme Court's 9-0 emergency order hit the public docket, it felt like a political earthquake detonated underneath the entire country. No warning, no leaks, no buildup, just an instant shockwave powerful enough to jolt every governor's office, legal department, federal agency, and state legislature into full-blown panic mode. Phones lit up like sirens. Emergency legal huddles were called before sunrise. Governors demanded immediate briefings. Reporters scrambled for answers. Even members of Congress admitted privately that they didn't see this coming. Not like this. And who could blame them? Because this wasn't a routine update, a procedural clarification, or a quiet legal housekeeping action. This was the Supreme Court of the United States, unanimous, decisive, and absolutely unshakable, issuing an emergency order that signals a seismic shift in how American law will look moving forward. A 9-0 ruling is rare. A 9-0 emergency order with national implications is almost unheard of, and the message behind it is unmistakable. America's legal landscape is about to change forever. This decision didn't arrive gently. It crashed into the national conversation with the force of a constitutional hurricane. For months, analysts predicted tension, but not a unanimous decision, not a united front from the most ideologically divided court in modern U.S. history. But something extraordinary happened here. Every justice, liberal and conservative alike, agreed that the lower courts overstepped, misapplied standards, or outright violated foundational constitutional principles. And when a Supreme Court speaks with one voice, it carries a power no agency, governor, president, or advocacy group can ignore. Overnight, the order triggered legal chaos in restrictive states, celebration among constitutional scholars, and absolute confusion among lawmakers who now realize their statutes may be on a countdown clock to collapse. The emergency order revolves around a case that many political strategists assumed would disappear quietly into the lower courts, stall for years, or get sidestepped by the justices. But instead, the court grabbed it aggressively and immediately, an unmistakable signal that the justices see urgent constitutional stakes. The case itself centers on a core question. Can states impose regulatory frameworks that clash with historical, constitutional, and structural rights recognized by the Supreme Court in landmark decisions like Bruin, McDonald, and Heller? But the December 9-0 order goes beyond this particular dispute. It freezes lower court rulings that upheld restrictive regulations, orders immediate review under stricter constitutional standards, and all but declares that ongoing state resistance to Supreme Court precedent will not be tolerated. It is a constitutional reset, a reminder that the highest court defines the limits of government power, not the states, not agencies, and not political coalitions. What makes this moment even more explosive is the fact that the Supreme Court has effectively placed several major categories of modern American law in jeopardy. Hidden between the lines of the emergency order is a sweeping message. If a law infringes on constitutional rights without strong historical grounding, it will likely fall. Analysts already point to at least 7 areas now on the chopping block. First, regulatory licensing systems that require citizens to obtain government permission before exercising a constitutional right are now facing unprecedented scrutiny. The court's unanimous signal suggests these systems may collapse if they impose delays, discretionary evaluations, or arbitrary requirements. Second, overbroad sensitive place restrictions, which exploded after Bruin, may be invalidated nationwide. States attempted to designate nearly every public location as restricted zones, but the court's new tone suggests a major crackdown on these expansions. Third, bans on commonly owned items, including firearms or tools widely possessed by millions, are now constitutionally vulnerable. Fourth, waiting period statutes, which delay the exercise of a right based on emotional or administrative reasoning, may not survive. Fifth, registration requirements that force citizens to disclose private information simply to exercise a right could be struck down. Sixth, discretionary rules frameworks that allow officials to deny rights based on subjective criteria are facing extinction. Seventh, Any state law built on public safety balancing rather than historical tradition is now fundamentally incompatible with the Supreme Court's direction. But this decision is not just about gun laws or permits or bans. The court's 920 order signals something far broader. The justices are preparing to redefine how lower courts handle constitutional rights altogether. For years, states have attempted to build modern regulatory schemes that circumvent or reinterpret Supreme Court precedent. But with this emergency order, the court finally drew a solid line in the sand. They are no longer allowing states to twist, delay, or sidestep constitutional rights through creative legislative drafting or flexible judicial standards. The message is unmistakable. Constitutional rights cannot be re-engineered by state governments, and any attempt to do so will be struck down unanimously if necessary. Inside legal circles, scholars are calling this the most important unanimous constitutional action in a generation. A 9-0 decision is not political, it's structural. It tells the country that the issue at hand is so fundamental, so clear, so constitutionally unambiguous that ideological differences vanish in the face of it. And if the court is united now, analysts believe the upcoming full ruling, expected next year, could become one of the most transformative decisions since the incorporation era of the early 20th century. The possibility of a sweeping constitutional realignment is now on the table, and every state attorney general knows it. Already, emergency meetings are being held. State legal teams are rewriting memos. Legislators are warning that their existing frameworks are at risk, and advocacy groups on both sides are preparing for what could become the biggest legal fight of the decade. At the center of this emergency order is something even more alarming for state governments. The court directly criticized the inconsistent and conflicting standards used across different jurisdictions. The justices implied that the Constitution cannot mean one thing in Texas and another in California, one thing in Florida and another in New York. This suggests the court may be preparing to impose a unified national standard, one clear rule that applies equally across all 50 states. That would be historic. It would dismantle the patchwork of contradictory systems that have defined state-level lawmaking for decades. It would eliminate regulatory loopholes that states have relied on to skirt around federal constitutional standards, and it would mark a dramatic shift toward uniform rights for all Americans, regardless of state borders. The political reaction is already explosive. Gun control advocates argue that the ruling undermines state autonomy and threatens public safety. They warned that regulations will crumble before new systems can be developed. But on the other side, gun rights supporters say the court's order is a long overdue correction to years of unconstitutional overreach. They see it as the Supreme Court stepping in to enforce rights that should never have been restricted in the first place. They argue that the unanimous vote proves just how far some states have drifted from constitutional boundaries. And they believe this emergency action marks the moment the tide finally turned in favor of individual rights. Meanwhile, inside Congress, political shockwaves are reverberating. Some lawmakers are calling for emergency legislative action to protect state authority, though experts say such efforts would almost certainly be struck down. Others are pushing for federal standardization to match the court's direction. The Department of Justice surprisingly has remained measured, but insiders report that DOJ attorneys are preparing for the possibility of national-level restructuring if the court issues a final ruling invalidating the frameworks now under review. In other words, Washington knows this is bigger than a single law or a single state. It's a structural, constitutional confrontation. What comes next may define the future of American law for decades. The Supreme Court's emergency order sets the stage for a full hearing that could rewrite the balance of government power. If the court declares that permitting frameworks, restrictive regulations, or discretionary systems are unconstitutional, entire state agencies may lose authority overnight. Right now, there is a sense of inevitability building, like the country is standing on the edge of a legal transformation that can't be stopped. Governors know it, attorneys general know it, lawmakers know it, advocacy groups know it, And millions of Americans watching the news can feel the momentum shifting. This is not the final ruling, but it is the warning shot, a unanimous warning shot, a declaration that the court is prepared to enforce constitutional boundaries regardless of political pressure, media narratives, or ideological expectations. The court has spoken loudly and unmistakably. The Constitution is not optional. It does not bend to state preference. It does not evolve through partisan agendas, and it will be enforced even if it means dismantling statewide structures built over decades. The next months will be intense. More filings will come. More lower court decisions will be frozen. More states will scramble to rewrite laws they now know are vulnerable. And when the Supreme Court returns with its full ruling, the consequences could reshape the country in ways few imagined just weeks ago. Because this 920 emergency order wasn't just a legal action. It was a constitutional signal flare, a national alert, a landmark moment that will be studied for years. America's laws are about to change forever, and the Supreme Court has made sure the entire country knows.